Good morning, everybody. Chapter 12, the Law of Agency, and this is Lesson 8. All right. Now, we are going to go straight to page 2, question 5. Consider a situation in which a principal is the seller, the agent is the listing agent, and there is no dual agency. Which of the following events will terminate the real estate agency relationship? And the answer for number 5 is 2. This will terminate the real estate agency relationship. 2, an act of the principal that is inconsistent with the continuation of the agent's authority. So let me read this again. It says, now consider a situation in which the principal is the seller, the agent is the listing agent, and there's no dual agency. So which event will terminate the real estate agency? And the answer I have verified is number 2, an act of the principal, who is the seller, that's inconsistent with the continuation of the agent's authority. Question 21. Alan is Peter's agent with the express authority to rent Peter's cottage for the summer months. However, in his capacity as Peter's agent, Alan accepts an offer to purchase the cottage instead. Okay. When Peter discovers the incident, he is so impressed by the price, he calls and tells the buyer that he adopts Alan's act. Which of the following is the result of these actions at law? Kind of weird, eh? And so the answer is 1. Peter has ratified Alan's actions, therefore the buyers cannot sue Alan for breach of a warranty of authority. I think I need to read this again. Alan is Peter's agent with the express authority to rent Peter's cottage for the summer months. However, in his capacity as Peter's agent, Alan accepts an offer to purchase the cottage instead. When Peter discovers the incident, he's so impressed by the price, he calls and tells the buyers that he adopts Alan's act. All right. So there's no problems here. Which of the following is a result of these actions at law? And the answer is number 1 on 21. Right? Peter has ratified Alan's actions, therefore the buyers cannot sue Alan for breach of warranty of authority. And why would they? Middle of page 2, question 41. Adele is a trading services licensee acting for a developer who is purchasing large blocks of land in Vancouver for a large development. Adele purchases some lots in the area for himself and discloses his identity to the sellers as required by the Real Estate Services Act on these purchases. He does not mention the purchases to his principal, the developer. Shortly thereafter, Adele makes a profit on the resale of his lots due to the effects of his principal's development on the real estate market. What is this an example of? And the answer for 41, the example of, is 3, a profit for which Adele must account to his principal. All right. Adele's a trading services licensee acting for a developer who's purchasing large blocks of land in Vancouver for a large development. Adele purchases some of the lots in the area for himself and discloses his identity to the sellers as requested by the RESA on those purchases. He does not mention the purchases to his principal, the developer. Shortly thereafter, Adele makes a profit on the resale of his lots due to the effects of the principal's development on the real estate market. What's this an example of? And it's an example of Adele being a smart cookie. 3, a profit for which Adele must account to his principal. All right, question 57. Coralie asked Tim to sell her car and her mountain bike for her while she was away on holiday. She gave Tim the keys to the car and told him to accept any price in excess of $1,700 for the car and $300 for the bike. Which of the following is an example of implied authority? And the answer is 2. Before Cherise was willing to purchase the car, she insisted that she test drive the car and had it checked by the Automobile Association, which Tim allowed her to do. So when Tim allows her to do something, that is implied authority. And we go to question, page 3, question 92. Which of the following statements is true? And the answer to this is 2. Only statements A and C are true. And A and C, A listing contract is a specialized form of agency contract. Yes, listing contract is a specialized form of agency contract. And also C, under the designated agency system, while the brokerage contracts with the seller or buyer, an individual licensee is appointed to act as the sole agent of that seller or buyer. So under the designated agency system, while the brokerage contracts with the seller or buyer, an individual licensee is appointed to act as the sole agent of that seller or buyer. So this is also true. Listing contract is a specialized form of agency contract, yes. And C, under the designated system, while the brokerage contracts with the seller or buyer, an individual licensee is appointed to act as the sole agent of that seller or buyer. Yes. So A and C is true, and that's number 2. Question 115. If under a principal's instructions, an agent makes certain representations concerning a property which are false to the knowledge of both the principal and the agent, then for all of the above will be applicable. And what are these all of the aboves? 1, the principal is liable because he or she explicitly authorized the tort. 2, the agent cannot escape personal liability by arguing that he or she was authorized to commit the tort. And 3, the agent will be personally liable for the tort. So if there's a principal's instruction, the agent makes representations that are lies, then 1, the principal's liable because they've authorized the tort. The agent cannot escape this, saying that, I was authorized to commit the tort, and then agent 3 cannot, or yes, will be personally liable for the tort. So all the above. 116, which of the following types of authority would not provide an agent with the sufficient authority to create a binding contract between his principal and a third party? And the answer is 3, assumed authority. So assumed authority does not provide an agent with sufficient authority to create a binding contract. But the other ones do. Implied authority, apparent authority, and express authority. Those all have enough authority to make a contract, but not assumed authority. So get that in your head. Assumed authority does not allow. All right? You to make a contract. 4, 83. Which of the following is not an example of a breach of contract? And you know what? This is wrong. All right, so I got everybody. I am going to make a note of this. Make a note of this, buddy. Shit. Squeeze me for a second. I need to make a note. I did a boo-boo. This one is not the correct one. Yo. So I'm supposed to be doing 151, but 151 is nowhere to be found. So I just made a note of that. All right, everybody. Good. So change that at the end, hopefully. 154. Which of the following statements is false under the common law of agency? And the answer is number 2, where the agent does not disclose that she's an agent and enters into a contract with a third party, the principal can have no liability for the contract. That's false. All right, if the agent doesn't disclose that she's the agent, she enters into a contract with a third party, the principal can have no liability for the contract. That is false. The principal does have liability. These other things are true, however. Number 1, an agency relationship is created when 2 people agree that one will act on the behalf of the other. Yes. 2, where the agent does not disclose that. Oh, sorry, that's a false one. 3, an agent who would not have capacity to enter a contract herself may be able to make a valid contract on her principal's behalf. That's true. Okay, maybe herself she can't enter into contract, but she can on her principal's behalf. That's true. And 4, an agency agreement may be either written or oral, or partly written or partly oral. Yes, that is also true. But the false thing is where an agent doesn't disclose that she's an agent and enters into a contract with a third party, principal can have no liability for the contract. No, the principal does have liability. 158. A multiple listing agreement is a type of exclusive listing agreement for the contract in which the contract requires the listing to be distributed to all members of the real estate board. Okay? To all members of the real estate board. So that's exclusive listing. You require the listing to be distributed to all members of the real estate board. That's a multiple listing. And then 5, 190. A person whom an agent represents is known in the law as the principal, right? Yep. The person whom an agent represents in law is known in law as the principal. 229. In which of the following situations where express authority exists would an agent have authority to act? And the agent has authority to act the agent is an infant. What? In which of the following situations where express authority exists, would an agent have authority to act? The agent is an infant. What? Okay, that's really weird. But the agent is an infant. That's the answer I got. 256. 256, where a licensee has complied strictly with the disclosure requirements of the Real Estate Services Act when purchasing a property. 2, the common law may still require further disclosure. All right. The RESA has disclosure requirements, but there may be common law disclosure requirements also. And then we have 6. 281, where a rep has misconducted herself or a member of the public has accordingly suffered damages, then 1, both the representative and the brokerage may be investigated by the real estate counsel. 301, when a listing contract is expired and the listed property is later sold to a buyer who was first introduced to the property by the listing brokerage during the listing period, the brokerage will, 301, answer 2, be entitled to commission where the seller and buyer have conspired to sell after the expiry of the listing to avoid commission. All right, so if this stuff's going on, they're entitled to commission where the seller and buyer have conspired to sell after the expiry of the listing to avoid commission. So in that situation, you could still get your commission. 321, Angus wishes to sell his residence. He's entered into a multiple listing agreement with a licensee at Castle Rock Realty. Which of the following statements is true? And the answer is 1. The multiple listing service is managed by the real estate boards, okay? Realtor.ca is managed by real estate boards. And page 7, question 334, an agency contract that specifies that the real estate brokerage shall be the sole agent for the owner with respect to the sale of property is called an exclusive listing. All right? Exclusive listing is when sole agent can, the real estate brokerage will be the sole agent. 354, when an agent, acting within the scope of his authority and having disclosed that he is acting as an agent, enters into a contract with a third party, the parties to that contract are 2, the principal and the third party. All right? The principal and the third party. 370, which of the following events will terminate an agency relationship? And the answer is 4, all of the above. What are all of the above? 1, revocation of the agency by the principal. 2, frustration. And 3, performance. All those things, revocation of the agency by the principal, frustration, and performance, they terminate the agency relationship. And then page 8, 400, where a principal and an agent has acted in such a manner as to lead third parties to believe that his agent has authority to perform certain acts on his behalf, and the third party, when dealing with the agent, reasonably believes that the agent has the authority that he or she represents, the agent is said to have, and the answer is 4, apparent authority. Apparent authority. 4, so basically, what is apparent authority? Is it where a principal of an agent has acted in such a manner as to lead the third parties to believe that his agent has the authority to perform certain acts on his behalf, and the third party, when dealing with the agent, reasonably believes that the agent has authority. So the agent has apparent authority. 408, which of the following is false? An agent's authority to act on behalf of the principal may arise, 408.2, contingently, which is false. The agent's authority to act on behalf of somebody called the principal is contingently. No, it's not contingently, but it is expressly, it is by implication, and it is by ratification. Expressly, implication, ratification, but not contingently. 418. Where an agent with express authority enters into a contract with a third party on behalf of his principal, and the third party knows he is an agent, who will the law recognize as parties to that contract? And the answer, 418, is 3, the principal and the third party. The principal and the third party, they are parties of the contract. 427, if there is no listing contract in existence, but the agent effects a sale of the principal's property at the request of the principal, the courts will, 427, 2, imply a promise to pay the agent remuneration. If there is no listing contract in existence, but the agent effects a sale of the principal's property at the request of the principal, the courts will, 2, imply a promise to pay the agent remuneration. And guess what, folks? I am out of here. I am totally out of here. And I will continue this in part B. You got that? Continue in the part